also technology can make things better by, for instance, making it possible to templatize a number of stages in the dispute. Take the first procedural conference, like I told you, because there's a certain number of things that needs to be discussed. Instead of giving free rein to the decision makers, let's say the arbitrator or a judge, to decide whatever, have a carte blanche on what is decided in a first procedural conference, if you can templatize it, which means you ask a series of questions. In an arbitration context, that could be things like, what is the seat of arbitration? What is the law governing the arbitration? What is the number of witnesses? What is the order of witnesses? What is the dates? And that dates can already be, you can make a scheduling intimation right at the very start. So in fact, what CODR makes it mandatory is in the first procedural conference itself, the tribunal sets the date for the entire hearing. So if, let's say, today is 29th of April 2020, then you say 1 week from now this submission has to happen, another week from there another submission, then witness statements need to be examined, etc. And all of that is diarized from day one till the date of the award. So again, you are making some amount of process improvements over an existing process using technology. Then coming on to, for instance, exchange of documents or conducting hearings. Now, the way hearings are conducted in an offline world is, if you go to court, for instance, you'll make an argument. And at least the practice in India currently has been that you provide the copies of the judgments to the court or the other side during the hearing itself. Now, you can use technology to make that better. You can make people serve advance copies of whatever the written arguments are, whatever the judgments that they're relying on, so that people can come prepared and make hearings more efficient. Or even if there is, for instance, a judgment or something that's being passed on during the course of the hearing, then at the same time, you also, by using a platform, say such as CODR, you are able to send it to everyone involved. And that the fact that you've given it to the other party has received it. What you would do in lawyer speak is, in court, you would sign an acknowledgement saying received copy on so and so and so date. You again eliminate the need for it. And that is already done on a platform. Also, during the course of hearings, if you're referring to certain material, you can very readily use functions like screen sharing to not only share that particular document with the decision maker, but also maybe take them to the relevant paragraph. All of us have probably come across a situation where you go to court, we're trying to take the judge to a particular paragraph. You give them a bundle of documents. Let's say, could you please flip to page so on and so on and so forth, go down to paragraph so and so. Invariably, some page number is misaligned, something's not right. And by the time you get to it, you've probably spent about half a minute just getting them to that page. And you've probably lost track of the way you're running your arguments. That can again be overcome by, for instance, sharing your screen, taking them to the relevant portion of the judgment, highlighting relevant portions of the judgment, and reading it real time. Again, things that are happening in an offline world with a technology improvement that is possible. That's on hearings. Then you take witness examination, for instance. Again, even for witness examination, one of the aspects where a lot of time is spent is just getting the witness to go through the documents. You've asked a witness a document, you're confronting the witness with a document. And again, by the time the witness is given a bundle, the bundle is opened, the witness goes there, time is spent. And note that, you might think, okay, what is this small process improvements, 5 seconds, 10 seconds, 15 seconds, but extrapolate it to about 200 questions and extrapolate it to all the costs attenuating to that. You're spending the arbitrator's time, you're spending the lawyer's time, you're spending the witness's time, you're spending probably the stenographer's time, all of which could have been saved simply by enabling something where you can, if you open a page, the witness also opens the same page. So just that little bit of cost savings, when you multiply it across multiple instances, actually makes it a really, really effective, efficient process. Also during witness examination, one of the biggest concern people express is, oh, what if the witness is being coached? What if, for instance, the witness is reading out from another parallel window on a video, on an ODR platform where everyone is telling him what to answer? What if someone is behind the screen trying to tell the witness what to answer? Now, all of us have done video conferences or video conversations enough number of times to realize that if someone is reading, because you're so close to that person's face, you can see their eyes. And if you can see their eyes, you can see whether someone is reading. For instance, if I'm reading like this, you can very easily track that I'm reading rather than answering a question. So it's very easy for you to pick up those things in an online world. So these concerns are exaggerated. Similarly, if someone's answering, instead of looking here, looking behind the computer, I am sure every one of you can tell me now that I'm not looking at my screen, but I'm actually looking at someone behind the screen. So these are things that again are overstated and exaggerated. So while there are perceived limitations of it, I don't think those limitations actually exist. In fact, another very commonly encountered limitation they say for trial is demeanor of witnesses. They say, you can't understand the demeanor of a witness, whether the witness is sweating, etc., during a virtual hearing. Firstly, how often has the fact that a witness has sweat made a difference to your ultimate award? Let's take trial court. By the time the final hearing is happening in civil trial, the person who's conducted the trial or the witness examination is long gone, either because they're transferred or they're elevated or any other such reason, or you've literally spent 20 years getting to that stage, so the memory is just gone from everyone's mind. So firstly, the whole concept of demeanor is grossly overstated. Second, in fact, ODR probably gives you a better ability to understand the demeanor of the witness, both one, because you're so up close, so you can actually, you can follow the eye movements, which are probably the biggest reflection of how a person is feeling. Second, also because an audio and video record of witness testimony. So for instance, if you are delivering an award or you're writing a judgment 10 months down the line, then you can very easily, let's say for instance, someone's picked up a certain answer. Now, if you think that the transcript is a little out of context, maybe you're not understanding what the witness was saying, you want to understand what the witness's expression was at that point in time, how confident the witness was, how maybe unsure the witness was, you can very easily go back to the audio transcript, click it and open it, and just replay the entire thing, so that you are able to come back and understand and assimilate what is it that the witness was saying much better than you would in an offline world. So again, even during trial, just by using these technological tools, you are bringing about a significant improvement in the manner in which justice delivery can happen. Then coming to the final stage of an award writing, there also technology can play a huge role. Now, if any one of you have seen an arbitral award, you will see that 60 to 70% of that award is something that's probably written by a clerk of the arbitrator, because they are that those are the sort of things that can be done without application of mind. For instance, it'll say things like, this is the name of the party, this is the address of the party, this is the legal counsel representing, this was when the first hearing, this was when the statement of claim was filed, statement of defense was filed, these many evidences were led, these many hearings happened, etc. Now, all of this can be automated and templatized, because you are doing the entire process on an online platform. And since everything has a digital record, it's very easy to pull that out and make it part of the award without anyone having to think too much about whether that is, without actually having to spend time drafting that piece. That way, you make the arbitrators focus on the actual decisions. In fact, another way you can try and make them focus on the actual decision is move away from our standard typical way of resolving disputes, which is by drafting 20, 50, 100-page pleadings. Why not draft pleadings in an Excel spreadsheet where you have a particular issue, you have an argument, you have multiple arguments in multiple cells. The defenses to each of these arguments is against each cell. The decision against each of those arguments is on a following cell. And that's again not something extremely novel. If anyone's aware of what's called a red fern schedule in arbitration, and for those of you who are not familiar, a red fern schedule is a glorified spreadsheet. What it basically says is, let's say I have made a request for documents. The other party has the option of responding to that request. When that other party responds, let's say they object to the request saying it's too broad or whatever, I can make a response to that. Once that round of iterations has happened, the arbitral tribunal makes a final decision on whether to allow that document production or not. That way, what happens is everything is done in a table and everything is tracked. So from the first request to the time of the ultimate decision, it's all there in one table, which is easily read. The same principle, if you take it and apply it in the context of decision making, you're achieving two things. One, you're avoiding long-winded pleadings, which are very repetitive, which is very it's almost, it's a typical feature of Indian litigation. You're moving away from that. Second, you are achieving a huge section 34. You're avoiding a huge section 34 challenge. one of the biggest grounds for challenge in any section 34 is either the arbitrator has not considered the arguments advanced by the party, or the arbitrator has considered material beyond the submissions of the parties. Those are the two very, very common grounds on which an arbitral award is challenged. Now, by making this process in a templatized manner, you are reducing those grounds of challenge. You are making the arbitration more focused. So that way, what will happen is you are also not only making a process improvement, you are making a substantive improvement in terms of the outcome of the dispute as well. So that way, I mean, again, I've taken you through the entire life cycle of a matter in a couple of rounds. The first round, what we did was try and see how, with very minimal introductions of technology, you can bring about some improvements. And the second round, on a slightly more deeper dive of how it is that we can make a significantly greater difference. And that will give you a sense that ODR is not a definition that can be met. It is a spectrum, and how much of it you use, it of course depends from case to case. Like, I mean, while I've talked about all the benefits of ODR, some of the limitations might be, let's say, for instance, you're talking about a hearing that's going on for a month. And this is typically, and again, some very high valued kind of arbitrations where there are 20 experts, 40 witnesses, etc. It's physically taxing to sit in front of a screen and have those kind of hearings day to day for about 30 days, which is what happens in a number of international arbitrations. So maybe their ODR is not the right fit. Another challenge with ODR is also that, interaction within a team is a little more limited. Let's say, for instance, not all of you, like in the present COVID scenario, let's say the instructing solicitor is not in the same room as the barrister, or your senior advocate is not in the same room as the junior advocates. It becomes difficult to communicate during the hearing. I mean, of course, it is possible to do it. For instance, there are chat functionalities, even here in Zoom. I can send a private message, and that private message can easily pop up. So I think even there, while the concerns exist, they may not be as significant as people would first make them out to be. But there are restrictions, and we need to admit that. The second thing is that, if there is an arbitral tribunal, if the arbitral tribunal has to confer between themselves, that's again something which is a little bit more difficult to do in an online setting, but it's not impossible. And I'll show you some example on my live platform as to how that can happen. But again, recognizing these limitations will make us see how it is that we can address it better. For instance, even in a sort of high court scenario, because let's say adjournments are so limited or whatever, people tend to prepare better when they go in for a hearing in a high court or a Supreme Court, as opposed to, say, when they go into a trial court, because they know that they probably get an adjournment very easily. Maybe that's the sort of mindset change you need. So if you think that there are limitations with communicating within each other during an online dispute resolution hearing, maybe you will prepare better. Maybe the importance of certain tools like, written submissions, written opening submissions will become much better. Maybe you focus a little bit more during your actual hearing on matters, on aspects that, you've already prepared very well, and you're able to communicate more effectively during the hearing. So there will be some amount of mental shift, mindset shift that will be necessary, but it's certainly not impossible. And it's, in fact, in my view, probably desirable to move in that direction. So maybe here, since I've spoken for a fair while, I will pause and see, Vignesh, if there are any specific questions that we have at this point in time. And maybe I'll continue for a little bit more with maybe the screen share feature that I have wanted to show, and then take some more questions towards the end. So let me know if there's anything we can do now.
Sure, Vikas. I was hoping that you could give us a little bit of an introduction on how you came up with this idea for online dispute resolution, and how exactly you launched your platform. What exactly was the objective behind it and the key purpose? Because at that point in time, probably a year back, online dispute resolution wasn't something which was greatly featured. Now it is becoming a very important topic in these times.
Correct.
So can you give us a little bit of a highlight and your idea on this?
Sure. See, in fact, when we started online dispute resolution, and we didn't start it during the COVID times, we actually started it approximately 1.5 years ago, because I think there's a genuine need for it. Like I said, firstly, the existing processes are extremely inefficient. Even everything from like the both ends of the spectrum. Let me start with maybe the simple value disputes. If you look at the low value disputes, in India, they don't have an out. So if you're looking at, for instance, a consumer dispute, obviously you have the consumer forum, but all of us know how consumer fora work. I mean, particularly for Vignesh, who's probably practiced with me in the same city. If we had to ask him how many days in a month is the state commission open, it'll be a single digit number. Now that makes it incredibly ineffective. Similarly is your district consumer forum and the national consumer forum. When people come to us and they ask us, okay, we want to file a case in the National Consumer Commission, when can we get this heard? Our answer is the first hearing you will get is probably 6 months or 1 year down the line. Now these are answers that are simply not acceptable. Next is on so far as the accessibility from a physical point is concerned. Even for those consumers, to just travel to attend court hearings was not effective. So we know the amount of time that's spent in court, the amount of adjournments that are sought. So let's say, for instance, you're one of the parties who wants to come, you've initiated a dispute, however, you've engaged a lawyer somehow. You come, and for the kind of hearings that you're necessary in, maybe you want to argue a matter, maybe you want to give evidence. We've seen the number of times that a witness has been present in court and the court still adjourns it. So that means you've wasted that entire day, and not just wasted it, but you've wasted with having achieved no purpose. Even when you've given testimony, you've probably spent 15 minutes in the witness box, but you've taken an entire day off. And that's not, in fact, restricted to litigation alone. Even in arbitration, the way it's conducted, the very fact that you have to come attend a hearing, schedule these hearings. Firstly, scheduling is a pain because there are such few arbitrators, their availability is so complicated. But even when you're able to schedule it, the first half an hour is spent trying to recap what happened in the previous hearing. The last half an hour is spent trying to figure out where the next venue will be, what will be for lunch in the next hearing, what is the 5-star hotel that you want me to give accommodation in, what first class fare will I be entitled to. So those are the things that are simply not necessary. And there are arbitrators who probably discuss cricket and everything under the sun during arbitration hearings, making them less than desirable. So to minimize all of this, we had already started thinking about how we can achieve this. And the best way we thought was, one, make it more accessible. Two, make parties more accountable. And both of those were achieved. One, because you're making it online, and two, because there's a possibility of recording these hearings. So that way, if at all they were concerned, they will now heighten that concern 100-fold, because they know that if this sort of clip gets played in the court, then they'll be put to embarrassment. So that sort of routine and through accountability is already something that we were thinking about. In the present COVID situation, that is amplified because there's simply no other alternative.
Thank you for that. And I think you can play your clip now, Vikas, so that we can have a view.
Sure. Now, maybe if you can just ask one or two more questions, Vignesh, I'll just get my clip in order. I can just
sure.
Yeah.
So we have a few questions. So I'll start with the first ones that we have. I think Anjan writes saying, what is the hindrance in initiating ODR in any method of resolution, that is, whether it be criminal cases or civil cases? So I think you've addressed mostly the civil side. So can you give us a bit of a highlight as to how, or do you envision this being a practice even in criminal cases?
See, criminal cases, I think, while it's certainly possible, there are certain restrictions. And I'll tell you some examples. Let's say you're talking about a murder trial. You need to physically inspect the murder weapon. That's not possible on an online dispute resolution platform. So I think there are fundamentally inherent limitations to an online dispute resolution platform. But is it impossible to use in a criminal trial? Absolutely not. What are the kind of things that you can use it for? You can use it to argue bail applications. You can use it to do what they call peshi, or presence of an accused in court. Why is it that the accused needs to travel from the prison to the court? They can very easily be made available there. You are saving on state resources, and in fact, even the sort of security that you're spending money on trying to ensure that these people don't escape, etc. You don't need to do it. So bail applications, for instance, if you have any other interim relief applications that don't really require extensive witness examination, you can very easily do it. If you want to do witness examination also, it is possible to do it. But I think people will be a little bit more reluctant, because unlike in a civil case where, for instance, intention is not very relevant, in criminal law, maybe intention becomes that much more relevant, because you're talking very much in that space. So maybe there, the demeanor that we were talking about, where, while I did say that it's probably has a greater longevity in an ODR platform, if a criminal trial is run the way it is supposed to be run, which is in a very short time frame, then maybe it is not a suitable case for ODR. But even there, like I said, there are certain elements where you can get ODR and use them. So, okay, maybe before we move to the next question, I will, because I recognize there's a couple of questions on arguments, etc. So I'll share this one short clip on where an argument happened. I will fast forward it a little bit when they're talking about the substance of the case, which is not particularly relevant for us. Just give me 1 second. Okay. So here, I'll probably just run you through it also. This is a case where on our platform, we created a new virtual private hearing room. We invited the parties. We formed that virtual private room. The registrar introduces himself or herself to the participants who are there. And then what the registrar does is upload all the case documents into that particular case. So here, for instance, there is a number of documents that are there sent to that platform. So everyone on that platform, which is both parties, have access to the case documents just then and there. So that as and when you want to refer it, it's almost like a court file. The court file is now there in this particular hearing room. Handed over control to the arbitrator. The arbitrator takes control, starts the video conferencing where they want the participants to attend.
Thank you. Both the claimant and the respondent will join this hearing, which is at a short notice, considering the urgency requested by the claimant in the matter. So this is a matter in the arbitration under the Center for Online Dispute Resolution rules.
So maybe I won't play the entire clip. Here is a bit where the arbitrator is introducing everyone to what the dispute is. We'll go to, for instance, where the claimant is making some argumentation, and here you will see
confidential information had leaked to conviction from. And I wanted to draw your attention in particular to the Website Development Services Agreement. Sir, if I may, I will share my screen with you. Sure. Are you able to see this? I'm sharing the contract with you, sir. And sure. In particular, yes, we can see. You can see it, sir. Clearly, yes. In particular, what I wanted to draw your attention to was clause 7, which, in our opinion, was a very robust confidentiality clause.
I'll pause here again. So here you see again, during the course of the hearing itself, the arguments were being led, and because the argument required reference to the contract and certain clauses in the contract, through a screen sharing facility, the agreement was shown, and you will see on the right hand side, all the participants are still there, they're on the window, and the relevant agreement is being read out. So everyone's attention is focused to just the right clause without anyone having to spend any amount of time just flipping through their respective pages to do that. Now there also, again, here, for instance, was a particular case where the dispute revolved whether there was some infringement on the design of the chocolates that were being made by one particular company. And here you're able to demonstrate that difference. In this particular instance, by way of sharing an image of the infringing article and the original article. But this can very easily be made into a video. And that video can be shown. And if people have had experience of how court hearings work, if you have to show a video, by the time you get the projector room set up, by the time you get all of those things up and running, it takes an incredible amount of time. Things that can happen over a snap of a button on an online dispute resolution platform. Now, I won't take you through more of the arguments. This is a response that was given by senior advocate Mr. Gopal Jain. And at the end of the hearing, I'll just take you through once the hearing itself was over. During the hearing, actually, let me just take you through the rejoinder here because that becomes relevant.
Precedent in Saltman Engineering versus Campbell Engineering, which is really considered the most seminal law on breach of confidentiality. And ultimately, breach of confidentiality as a body of law is based on presumption for the simple reason that you are proceeding on the primary assumption that the information in question is not in the public domain in the first place.
So here is a case where, because the arbitrator asked a particular question, the claimant had to give a response on the spot. Now, the claimant in this particular case has probably not shared this particular case, so they're not able to share it with the arbitrator immediately at that point in time. But that, again, is very easily done. So you will see that the arbitration has completed, and immediately after the arbitration was completed, you will see the claimant in this case, Shwetashri Majumdar, has sent the judgment, Saltman Engineering, to the arbitrator and the other side shortly after the hearing. And you'll see that it is about 5 minutes after the hearing. so that the arbitrator can then go through it and see if there is any further comments that the arbitrator needs to provide. And you'll see it's not just that this particular judgment was given. Shortly after that, the administrator of CODR also uploads a transcript of the hearing. Now, if you will see the transcript, I don't know if the video quality is great, but this is a verbatim record of who said what. So Vyapak Desai at 5:12 said XYZ in a verbatim record of exactly what they're doing. And in addition to the verbatim record in a physical sort of PDF format, there is also an uploading of the video of the entire hearing that is shared with the parties. Now, I'll maybe stop there for the moment and get back to the discussion we were having. This is an illustration of a hearing that happened where an actual argument was taking place, where documents were being referred, exhibits were being referred. There was a question answer session, a judgment had to be relied on, that was sent subsequently by the parties, etc. All happening real time. And if you were to imagine this happening in an offline world, when you're trying to make these arguments, firstly, you have to schedule all of these things. Second is you've had the hearing. Third, you want to send some documents post the hearing. All of us know they'll probably set another date to receive those documents, or you will have to serve the other party, serve it with the registry. And by the time it comes to the court, you've probably spent about a week, 10 days in best case scenario. That can, of course, be done in a matter of seconds on this sort of a platform. Again, let me pause there and see if there are any further questions before showing you another demonstration that will probably help you understand a few more elements of this.
So I have a question here by a person who essentially has brought out the same issue as the Bar Council of India president did yesterday, that 90% of the people who practice law are not very familiar with using an online platform, and how to overcome such an issue, and what are the challenges, and how exactly to take care of that challenge and ensure that it no longer is a stigma, because change always begets stigma. How to get over that stigma. So what are your thoughts on that, Vikas?
Sure. See, I think that concern, I'm not saying it doesn't exist, but I think it's overstated, again, like a lot of things. I always give the example of my house help. She doesn't know how to read English. She doesn't know how to read Kannada. But I still communicate with her. How do I communicate with her? I communicate with her on WhatsApp. Not because she can read, but because she can play that audio clip that I've sent to her, and she can hear and probably respond to me by way of an audio clip. Does that mean that she's excellent in technology, that she can code? No, she doesn't. She probably has the most basic knowledge of technology, but it's about making technology as intuitive. Now, please tell me, in the hearing that we were conducting, what are the kind of technology that you need to learn in order to be able to present effectively? Let's again go through that thing. You have to log into a platform. Now, how many people don't know how to log in? I'm not saying that there aren't. There may be. But how difficult a skill is that to pick up? Every time you register for WhatsApp, if you have a WhatsApp account, you probably created it. If you've created it, you know how to enter a form which says, please enter your name and your email address or phone number. That's all it takes to create an account. The administrator automatically adds you to the group. And if you've added to the group, you can follow that. It's like a chat conversation. You've sent some message, the other party sent some message, etc. Starting a video chat. It's as simple as clicking that, that icon which looks like a camera, which again, people are so used to doing on their phones that it's not particularly difficult. Then during the video conferencing, the only feature you'll probably need to know how to do is to share your screen, which is just click that one button which says share screen, and stop share when you need to stop share. In all, I've probably said a sum total of approximately 10 commands that you need to know to use well. Now, I don't think that's a difficult task. Certainly not, given the huge advantages that it has to offer. But despite that, I have some sympathy for the letter that was sent yesterday. And I'll tell you why. Because the way technology is adopted as of today is ridiculous. You are not using technology that is intuitive. You're not using technology that is easy to use. You have so many hurdles. In fact, take the video conferencing app that maybe the Supreme Court or the Delhi High Court is using. They are not very intuitive. You need to know like far greater. In fact, when we were trying to do a hearing before the NCLT Chennai not too long ago, they use again the same video app, and it has such ridiculous limitations. It can have only about 4 people on at a time. I know there are the links don't work most of the time. Troubleshooting is necessary 90% of the time. Now, if that is how WhatsApp was, no one would use WhatsApp. If that is how Facebook was, no one would use Facebook. And you would always say, oh, no, I want to make friends in the real world. What is this making friends on an online medium, which always keeps crashing? So I think it's about giving people the experience that makes them realize that it's seamless. Because that is not what the courts have done today, that is why the letter has come. And I think that can be very easily overcome by presenting them something that is intuitive and easy to use.
All right, that answers that question. There's another issue which probably has been highlighted by another person, which is the difference between a seat and venue, especially in arbitrations. Could you please shed a little bit of light, especially about the seat point when it's in an online dispute resolution platform? What would be the seat in such situations?
Sure. See, my answer to that is pretty straightforward. Even today, when you have arbitrations, arbitration hearings are conducted in a number of different places, including electronically, including over video conferencing, including in 5-star hotels. In fact, the same example that I gave, where there was that Guatemalan dispute from America. While some hearings we conducted electronically, there are certain hearings that we conducted in London, even though the seat of arbitration was Singapore. That does not mean that Singapore becomes any less a seat. It is legally what the parties have chosen to be the seat. Very similarly, even in an online hearing, the contract or the arbitration will be seated in whatever place it is. In fact, the standard CODR clause would recommend either a Bombay, Delhi, or a Bangalore. So once you choose that, that remains the legal seat of arbitration. It does not matter if you don't visit Delhi, Bombay, or Bangalore even once during the course of the hearing, because the venue can be anything. And in this particular case, the venue is the online platform.
Okay. And there's one last question, and probably a very interesting one here. So, person has commented that they couldn't see a stenographer in the video that you showed. And how was the record of the proceedings done?
Yeah, in fact, I was desperately trying to get that video. I have that video. So why don't we park that question, and I will show you a video demonstration of how we can do it with a stenographer.
How about we see that right now? Would that be
yes,
possible?
In about 5 minutes. Let me pull out that video. Or maybe I'll answer the next set of questions in that time.
Sure. And just so that we may understand your platform better, how are the timeframes conducted? Is it individual, or is there a set of rules? Is this an institutionalized mechanism? And can you please shed a little bit of light on that?
Sure. So in fact, the platform is very modular. You can use the platform to resolve existing disputes, in which case the platform doesn't fix any time limits, nothing, because it is your ad hoc or institutional arbitration that you're trying to resolve on this particular platform. But when it comes to an institution, we have a set of rules. We have, and then the institution administers the arbitration just as an SIAC or an ICC would do. And those time limits are applicable to those kinds of arbitrations. In that case, there's obviously far greater control that we can bring to the entire setup. But if you're using simply the platform without the institution, then the time limits are entirely up to whichever institution is administering it, or if it's an ad hoc arbitration, with the arbitrator entirely.
That seems quite nice. And finally, Vikas, the last question that we probably have right now is, what would be the kinds of disputes, say, for example, if we take arbitrations or a set of civil law cases, what would be most beneficial, or what subjects would be the easiest to be resolved through an online dispute resolution platform, according to you?
So I think, like I said, in so far as civil cases are concerned, I think the entire spectrum of civil cases can be filed on that, resolved on an online dispute resolution platform, no exception. I think the only places, like I said, where there would be a little bit of a challenge is where they're super complicated with about 50 witnesses or 100 witnesses, which might become a little unwieldy. Given that, I think certainly the appeal would be the highest for low value disputes, because they simply don't have an option currently. I think the option would, the solution will also make sense for high value disputes in the current scenario, at least, because there's simply no alternative available. In fact, when I was doing a webinar, and it's quite interesting that we had a webinar a few days ago with the SIAC, the Singapore International Arbitration Center, on how to conduct virtual hearings. And a little bit of an insight, the idea of the webinar didn't come from CODR. The idea of the webinar came from SIAC. SIAC reached out to us and says, are you guys interested to do a webinar? Which means that even in the very high value disputes, even in existing arbitration disputes, they're interested to use technology and platforms such as this to try and resolve it. So I think to say that it's only fit for one or the other kind of dispute is just doing it disservice. In fact, the way our platform is structured is it's even available for instance, family law mediations. It is available for POSH inquiries, prevention of sexual harassment inquiries, where confidentiality is key. I mean, you don't want to be seen entering a room where the POSH inquiry people are there. For internal disciplinary inquiries, where you're trying to terminate an employee or whatever. So the possibilities are endless. And maybe with that, Vignesh, I will go back to sharing my screen to just show you that little bit of a demonstration that I wanted to.
Sure.
So this is the case where, the question said, you wanted a stenographer, you have a stenographer.
Cost title already populated. So this is the
In this,
examination in chief of Mr. What's the name?
Sorry, in this particular case, I'll just avoid my annoying voice on that hearing. So here is a case where you will see on the right-hand side, we had a mock hearing. This is not a real case, where you had the claimant's witness, you had me, the arbitrator, you had the respondent witness, you had the witness, and the stenographer whose video is not really relevant. So the stenographer is there. The stenographer has shared the screen, and examination in chief is going on as we speak. And as the stenographers do, they put out the standard form, then there is the taking of the oath. Then what we did, the examination in chief was completed. The cross-examination, you will see, the examination in chief is going on where the witness's examination, the affidavit was shown, the witness confirms that. Then what we do is we go into cross-examination. There's a case where, cross-examination also. The cross-examination questions are being typed up as you speak. And as this is done, the witness in this particular case is seeing the question and answering the question. And this again is happening with the help of stenographers who we are using real time. So here we again offer that service. We have technology trained stenographers who are willing to come and assist on an online dispute resolution offering. And this again goes back to your question. If stenographers are capable of embracing technology, why can't lawyers embrace it? And that will probably serve your question of if 90% of the lawyers are not trained, maybe they need to upskill a little bit.
Yeah, sure. Finally, I have a question by Isha Agarwal, who asked quite a pertinent question. How exactly do you need to file a record of online arbitral proceedings, especially in a Section 34 petition, challenging an arbitral award? So you can answer that for her.
Sure. So in fact, if you go back to the previous screen, in the first video I showed, you saw that there was a virtual hearing room. Now that virtual hearing room is what it says. It's almost like a hearing room that is dedicated to you for the life cycle of the arbitration. So if you start the arbitration today, from there until the end of the arbitration, you have that hearing room to yourself. And that hearing room logs every single activity. Who came onto the platform? When did they come on? What did they do? Did they send a document? Did they start a video chat? Did they end a video chat? Did they send some documents? Was some comments made? Was that exchanged? All of it is maintained in that hearing room. And it's encrypted and it's very secure. In fact, even as an admin, if let's say there is someone else who's initiated arbitration on our platform and I don't have access to that hearing room, I don't have access to the documents, but we can, as an institution, give you a record of that particular hearing room. So if you want to take it to a Section 34 court, you can either print out that entire conversation, or you can give it to them on an electronic format for them to use to say, okay, this hearing actually happened, etc., etc. So hopefully, if we get integrated with court systems, we won't have to print it. And this record can automatically get transmitted to the court file and they can open it on their systems if they also go virtual. But it's certainly available for you to print if necessary to file a Section 34.
Thank you, Vikas. That was a really nice session with us. It was a lovely, lovely session. Thank you so much for shedding light on these pertinent aspects and also giving us a few videos to understand the beauty of an online dispute resolution platform and the benefits of online dispute resolution in itself.
Sure. I mean, Vignesh, I know we're running to the end of time, but if I'm given 3 or 4 extra minutes, I just had a couple of things to say, which I just want to repeat for people.
Of course.
There's a couple of things that I've heard of. What does this mean for lawyers? And since I know there's a number of young lawyers there, and I've already used words like, you don't need a lawyer. Does this mean that ODR is a threat for lawyers? Those are the sort of things that are natural and legitimate to ask. And let me answer that question. It doesn't mean that lawyers become irrelevant. I think it just means a change in track. One is upskill lawyers using technology so that you are able to solve these disputes. Second, don't look at lawyering as this silo where you just do advocacy. Why not career arbitration practitioners? Why not become career arbitrators? In fact, if you look at every country apart from India, arbitrators, 95-98% of them are not retired judges. It's only in India that 99.99% of them are retired judges. we can certainly change that. And for low value disputes, if you need to make dispute resolution affordable and accessible, you need to make it available. And that can only be done if slightly lower cost resources, such as us lawyers, become arbitrators. So I think it's one, equipping yourself to understand technology. And I think the second is to upskill yourself to become arbitrators so that you have another career track that's open and available in front of you. Second, an aspect which I was hoping to demonstrate, and I think we're end of time, so maybe I can't, people can write to me if they're interested, is one of the limitations of ODR that we had discussed briefly was the inability for teams to communicate between themselves and for the arbitrators to communicate between themselves. And there's a 3-member tribunal. Now that is very easily sorted on the CODR platform by doing what is called caucuses. I mean, if people are familiar with a mediation, now what is a mediation caucus? A mediation caucus is when you have a virtual hearing with just one party or the other party or just the counsel, whatever combination you want. That's easily done. So what we do is we enable 2 hearing rooms. We enable 1 hearing room for all of the parties. We enable 1 hearing room for just the arbitrators. And if you want 1 hearing room only for the claimants, 1 hearing room only for the respondents. So even in the middle of an arbitration, you can, just as you would in probably a real arbitration, say, if Mr. Arbitrator can excuse me for a minute. So you step out of that virtual hearing room into the other hearing room, and literally this takes about 2 seconds to do. So you click to the next virtual hearing room, open up a video chat there, and that video chat is only to your team. So if it's just the arbitrator, it's just the arbitrators. You have that and come back. So I think that limitation of being unable to communicate within your own team is also capable of being minimized. So you can have your caucus sessions, arbitrators can do their own internal deliberations, etc. And then we can step back into the real life. I know I said 3 points, but I seem to have forgotten the last bit. But if I do remember it, then I'll probably drop it off as a chat in the YouTube recording that is there. But yeah, back over to you, Vignesh.
No, you can continue, Vikas. You can complete your last point.
Correct. Appeal. That reminds me. That's actually another feature which CODR offers, which is quite intuitive. Now, historically, if you're not satisfied with an arbitration award, people say that the only recourse is to court. So you go file a Section 34. And in a number of circles, that's seen as a limitation. Because you're like, what if that arbitrator gets it wrong? And look at the very limited grounds available for a challenge in a Section 34. You cannot relook at issues of questions of fact, questions of law, unless there is a patent illegality, etc., etc. So people say, you know what, for that reason, I think I want some amount of safeguard. So let me go to court. CODR makes an improvement there by ensuring that there is an appellate remedy available even within the institution. And that is only applicable for CODR institutional rules. So if people have heard of the judgment of the Supreme Court in Centro Trade, that is a judgment which dealt with tiered arbitration, which basically means that you go for an arbitration and you say, if you're dissatisfied, go for another arbitration, which is called appellate arbitration. The Supreme Court said that's perfectly valid and legal. Both of them are arbitrations, and there's nothing inconsistent with the Arbitration Conciliation Act. And that's an option we provide on the platform. So if there is a party who's genuinely dissatisfied and they want a speedy, efficacious appeal, it's available within the platform. And that's why we wanted to make some improvement over court systems. Because if you look at the courts, especially in Karnataka, trial court, if it takes 6 years, in the High Court, it probably takes you 20. I mean, I'm currently trying desperately to get a matter listed for final hearing in an RFA from 2008. And that is of a suit from 1994. So you can imagine that that sort of frustration we don't want people to have, even if they've come to the platform, got an arbitral award, and they're going for a Section 34. And we hope that having gone through and having had the option of availing appellate arbitration, if they do still go to Section 34, the courts will be that much less willing to interfere, because you've already gone through 2 rounds of iteration, and the court will hopefully say that it's certainly nothing outrageous, nothing patently wrong with this award.
That's great. Thank you so much, Vikas, for this wonderful webinar. It was a pleasure hosting you, and it was really nice. So thank you, and we hope that we can have another webinar when required on this topic.
Absolutely. I mean, there's plenty to speak about this, and I'm sorry if I rushed through that 1 hour with so much of information, but I hope people found it to be helpful. And if you need any more information, then follow us on LinkedIn. We are Center for Online Dispute Resolution, and happy to answer questions there.
Sure. Thank you so much.
Thank you, everyone.